A Supreme Court decision just dropped that could change how millions of gun owners carry in public, and if you don't understand what it actually said, you could end up trusting a law that no longer exists the way you think it does. Quick question before we go any further. Are you subscribed to this channel? Because I'm about to walk you through the exact wording of a 623 ruling, the part gun stores are not telling you, and one simple habit that will keep you legal in every state you drive through. Hit that button right now so you don't miss the next one. Here's what just happened. On June 25, 2026, the United States Supreme Court issued a decision in the case of Wolford v. Lopez. 6 justices said yes, 3 said no. The court struck down a Hawaii law that made it a crime for a person with a valid concealed carry permit to walk onto private property that was open to the public, unless the property owner had already given express permission. Think about that for a second. Before this ruling, a lawful concealed carry permit holder could be arrested simply for stepping onto a private parking lot, a privately owned shopping strip, or a private park that invited the public in, because the default was no. Guns allowed unless someone said yes first. The Supreme Court just flipped that default on its head. Permit holders no longer have to ask permission to be where the public is allowed. Let me explain why this matters to you, even if you have never set foot in Hawaii. This isn't a Hawaii story. This is a Second Amendment story. And Second Amendment rulings from the Supreme Court send shockwaves through the entire legal system. First thing to understand, the Supreme Court only takes a handful of gun cases every year. When they take one and they win, every circuit court in the country has to pay attention. Lower courts cannot ignore a Supreme Court ruling. State legislatures cannot ignore it either, because state lawmakers know the next lawsuit is already being filed. So when the Supreme Court says concealed carry permit holders can carry where the public is invited without asking first, that principle is going to be tested in dozens of other states very soon. Second thing to understand, the court didn't just strike down one sentence in one Hawaii statute. They explained the reasoning. The justices looked at the historical tradition of firearm regulation in this country. They asked whether requiring permission before carrying a firearm on private property open to the public matched any tradition that existed when the Second Amendment was ratified. The answer was no, so the law failed the historical test the Supreme Court laid out in the Bruen decision back in 2022, and it was struck down. Now this is where it gets interesting for you as a gun owner. Third thing to understand, the decision changed to practical things on the ground, starting immediately. Number 1. In Hawaii, permit holders can now carry on private property open to the public without first asking for permission. That's the obvious change. Number 2, and this is the bigger one, every other state that has a similar law is now vulnerable to the exact same challenge. Because if the Supreme Court says Hawaii's version of this rule is unconstitutional, then every other state's copy of this rule is in serious legal trouble. Let me give you a hypothetical example to make this real. Imagine you live in one of several states that have a sensitive places list, that list names types of property where firearms are restricted. Some of those lists include private property open to the public, like concert venues, restaurants, or privately owned shopping areas. Before Wolford v. Lopez, the assumption in many of those states was that carrying on to those properties without explicit permission could be lawful only if you had permission. After this ruling, the default is changing in those states too. Law-abiding permit holders will have stronger standing to challenge those local rules. But here is the part nobody is talking about yet. Here's the crazy part. The state of Hawaii and several other states are not going to give up quietly. They are going to try to redraft their laws. They are going to use narrower language. They are going to claim that their new rule is different enough from Hawaii's old rule to survive review. That fight is going to happen in lower courts for the next 1, 2, 3 years. In the meantime, the laws on the books in your state are still enforceable unless and until a court strikes them down. So the practical legal reality right now is this. The big principle just won. The day-to-day application in your zip code is still messy and inconsistent, and based on which judge hears your case. Let me break this down for you even more. The Supreme Court is not telling police officers that they can no longer enforce these laws today. They are telling judges that these laws are unconstitutional. Those are two different things. A police officer on the street who stops you for carrying in a place that just became legally protected can still write you a citation. That citation will eventually get thrown out by a judge, but you'll have to fight it. That fight costs time. That fight costs money. That fight creates a paper trail. If you're finding this useful, here's the value promise for next week. My next video covers the exact 5-word script that protects you when an officer asks where your firearm is during a traffic stop. The words are short, polite, and they work in every state. Hit subscribe now so you catch it the day it drops. Here's what most gun owners get wrong about cases like this one. They hear the headline, they celebrate, and they change their behavior immediately. That is a mistake, and I want you to avoid that mistake. Here's why it's a mistake. The Supreme Court has done its job. It has clarified the constitutional standard. It has flipped the default, but it has not personally rewritten your state's penal code. It has not sent a memo to your local police chief. It has not told the prosecutor in your county to stop filing charges. State and local officials operate under their own reading of state law, and they are allowed to keep enforcing that state law until a state court or a federal court in their circuit tells them to stop. I want you to think about 3 specific scenarios that could happen to a permit holder right now because of this decision. Scenario 1. You are traveling through a state that still has its old sensitive places rule on the books. A police officer sees you carrying in a place that the Supreme Court just made constitutionally protected. They stop you, they ask questions, they may issue a citation. The citation will likely be dismissed later, but the stop happens now. Scenario 2. You carry in accordance with the new ruling, and a property owner asks you to leave because they personally do not want firearms on their premises. They have every right to ask you to leave. You must leave. The ruling did not give you the right to stay on private property after the owner says no. It removed the prior restraint. It did not eliminate the owner's right to exclude. Scenario 3. You mention the Wolford case to an officer who has not been briefed on the decision yet. This is where it gets awkward. Some officers will know exactly what you're talking about. Others will not be familiar with the ruling because it is brand new. The friendly way to handle that is to comply respectfully, explain later in court, and never let the moment turn into a confrontation. A pause for a quick legal note. This is educational information, not legal advice. Every state, every county, and every local jurisdiction still has its own rules. Always consult a licensed attorney in your state for your specific situation before you change how you carry. Hey, real quick, here's a community note for you. Right now, almost 3 out of 4 people watching this video are not subscribed. That means most of the people who need this information the most will not see the follow-up videos. Don't be in that group. Join the tens of thousands of gun owners who already get these updates first. Click subscribe, turn on the bell, and let's do this together. Now let me walk you through what the dissenters argued, because understanding the other side is how you stay out of trouble. The 3 dissenting justices wrote that the court was overreaching. They argued that states should have wide latitude to regulate where firearms can be carried, especially on private property. They pointed out that private property owners have rights too. That is a serious argument, and it is going to come back up in future cases. What does that mean for you? It means the legal fight is not over. It means even if today's ruling helps gun owners, future rulings might cut back on it. It means that staying informed with content you can trust is the single best long-term protection you have. Here's the part that shocked me when I first read the decision. The court did not just rely on the Second Amendment text. They leaned heavily on the historical analysis framework they created in the Bruen case. That framework asks judges to compare modern gun laws to what was historically accepted at the time the Second Amendment was ratified. If there is no historical analog for a modern restriction, the restriction is presumed unconstitutional, and the government has to prove it is consistent with the nation's historical tradition of firearm regulation. For Hawaii's law, the government could not meet that burden. That is the engine of this entire decision, and that engine is going to keep running against other state laws in the near future. Right now, the Supreme Court has also agreed to hear cases challenging bans on AR-15 style rifles and similar firearms. Gun rights groups are watching those cases closely. If the court applies the same historical analysis to those bans, the result could change the legal landscape for millions of rifle owners. We will cover those cases in detail when the rulings come down. Subscribe now so you don't miss that breakdown. Before we get to the closing, let me give you the practical takeaways. Takeaway number 1. The default has changed. In Hawaii, concealed carry permit holders no longer have to get express permission to carry on private property. Open to the public, this information could be challenged, narrowed, or expanded by future courts. Subscribe to stay on top of those changes. Takeaway number 2. Other states with similar provisions are now legally exposed. If you live in or travel through such a state, watch local legal news closely and consider consulting an attorney about how this ruling affects your specific carry habits. Takeaway number 3. Private property. Owners can still ask you to leave. Compliance is not optional. The ruling removed prior restraint. It did not eliminate the right of a property owner to exclude. Takeaway number 4. Always comply respectfully on the street. Always challenge if necessary in court. Those 2 principles work together. Takeaway number 5. Stay educated. The legal terrain is shifting fast, and the best protection you have is up-to-date knowledge from sources you trust. Laws change fast, really fast. Subscribe now so you are never caught off guard when the next major ruling drops. The next video breaks down exactly what to do if an officer stops you while you are carrying, including the exact words to use, the exact phrases to avoid, and the small mistake that gets most gun owners into trouble. Now, let me close this out. The bottom line is simple. On June 25, 2026, the Supreme Court handed concealed carry permit holders their biggest legal win in years. It struck down a state law that made the default answer to carrying on private property open to the public an O, and it flipped that default to a yes. It also opened the door for dozens of similar challenges across the country. This is a victory for the Second Amendment. It is not the end of the fight. It is the beginning of a new chapter. You know what's worse than not knowing about a gun law change? Finding out about it after you have already broken it. Subscribe now so you stay ahead. This video is educational content, not legal advice. Always consult a qualified attorney in your state for guidance on your specific situation. Stay safe, stay informed, and I will see you in the next one.